must prove that the defendants with criminal negligence caused a child under the age of 18 cruel or excessive physical or mental pain. Criminal negligence is an act or a failure to act which demonstrates a willful, wanton, or reckless disregard for the safety of others who might reasonably be expected to be injured thereby. Like witnesses have stated, the parents did seek attention and were told it's just a tissue mass. As far as Ricardo, it's the criminal negligence. Vitamin D. Ricardo never had any health issues. None of the children really ever had any health issues. They never got cold and never had the flu. They were healthy. Let's move over to the burden of proof. The defendants are presumed to be innocent until proven guilty. And the burden of the proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. During my opening statement, I asked that you keep an open mind, that you take the time to actually look at the law and to consider the facts and the evidence, both from the state and from the defense, to determine whether or not you had credible witnesses, to determine whether or not the parents acted maliciously in causing physical or mental pain, to determine if the parents acted with criminal negligence towards their children and causing them physical or mental pain. As stated before, a man of few words, and that at the end of your deliberation, that you take everything into consideration: credibility of witnesses, the intent, the malicious intent. Were the parents actually maliciously intending to do harm? At the end of your deliberation, if you feel like there's any doubt to any of these questions, the state has not proved within a reasonable doubt that the defendants are guilty. With that being said, I would ask for you to enter a verdict of not guilty. Thank you.
All right, thank you, Mr. Wimbush. Mrs. Wimbush. Let me get the bailiffs to assist you. And do we have markers in here as well?
Okay. It's still on there.
Okay, I won't need it. I don't need it. He says still written on it.
It's still on there.
Yeah.
Can we just angle it a little bit more so it's facing the jury, please? Thank you.
Can everybody see it? Really, how are y'all doing? Almost. Ladies and gentlemen, when I first addressed you on Tuesday morning, I told you that though I may have credentials on paper that some may value, I value most being a wife and a mother, and that in fact, this is how I determine my self-worth. I also told you that I don't have any legal training or any legal education, and so I have shown you that over the past 2 days. And I told you that although I'm merely a layperson, that just like that ruddy little shepherd boy, David, fought a bear and a lion to save his sheep and showed himself fearless in the face of Goliath, that we fight for the family For family is the most important and fundamental aspect of life and is the foundation of a true democracy. I told you that there are two major lessons that I've learned in this life. That it is easier to believe a lie than it is to believe the truth. And two, that education is the first line of defense. I told you that the lie was that we caused two of our children, two of our precious little sheep, cruel and excessive mental and physical pain, and that we denied one food and water necessary to maintain life. I told you that the truth was that we did neither of these. I then told you that just like you, I too did not know what exactly the offense of cruelty to children was, and I further told you what I've learned that this offense is over the past 2 years. In fact, I wrote out exactly what each of these offenses meant in terms of the essential elements of the crimes. We have first degree, Part A. And Mr. Wimbush just kind of covered these, but I'll cover them again. And the 4 essential elements that the state is required to prove, each and every essential element of each crime beyond a reasonable doubt. Number 1 for Part A, the defendant is a parent or guardian or other person in charge of a child. The child is under 18. The defendant willfully deprived the child of necessary food and drink sufficient to support life. That the deprivation of food and drink jeopardized the child's health or well-being. First degree Part B. The child is under 18. That there exists evidence that the child suffered mental or physical pain. That the pain was cruel and excessive. That the defendants caused the pain. And then for Part C, the only difference from Part B is that it's no longer malicious. It now becomes with criminal negligence that the pain was caused. Then I challenged you to look to your inner childlike spirit and treat this trial like a scavenger hunt, where you are the fact finders, even the truth seekers seeking to find the pieces to the puzzle that describes cruelty to children in 3 different ways. Well, I have to tell you, yesterday blew past me faster than I could have imagined, so I had to stop and consider exactly what was said. So I summarized my findings as I also treated this trial like a scavenger hunt to expose the truth. 2 things you learned about my oldest son is that truly he is, as his sister describes him, a perfect child. That truly everything he touches turns gold, and that he had a few concerning character flaws when at 13 he was at a crossroads where pride, his lack of remorse, and his battle with lying placed him at the gate, that wide road of possibilities that lead to destruction. And so my child had to be somewhat restrained in order to be retrained and fully be aware of the choice that lay before him, the narrow road that leads to life, or the scary wide road that leads to destruction. You also learned that he was not told that he had to stay in his room in the basement, but that whenever he decided that he was ready, he could move right back upstairs with everyone else, and that his room being in the basement could not be permanent, but that we wanted him to hurry back and have his bed placed back in the sleep room in its rightful place. And that took a lot of teaching, a lot of training, a lot of encouraging, a lot of hugging, a lot of crying with him to get him ready. In fact, you learned that we had just, not even 2 days before the first visit from DFCS, decided that he was on his way back upstairs. And what a joyous occasion that was. Nevertheless, no one can account for what will be. For many are the plans of a man, and then there's Yahweh. You also learn that Isaiah is a free, fun-loving child who was literally bouncing off the walls with energy and perhaps a little clumsy, but a truckload of laughs indeed. And that he was happy and healthy at home. Well, I hope I haven't bored you to death yet, because now I'd like to share with you the pieces of the puzzle I found based on the testimony given by witnesses. Ms. Patricia Boone told you that someone else was the first to respond to our home on June 15th, 2014. And that person talked to all 10 of my children and did not seek to remove any one of them from their home, and that everybody was happy, healthy, and safe. Ms. Boone then told you that she was then sent to our home to learn on June 16th, 2014, to learn more about our religious practices, like not believing in immunizations, that she spent 2.5 hours asking solely about our lifestyle. And then as our Shabbat or Sabbath approached and we needed to prepare, she left, having not talked to any children and stated no concern for their well-being. Moreover, there was no outcry from any child, and no child was ill. Ms. Boone then told you a complaint was filed in juvenile court on June 18th of 2014. And we were subpoenaed to be in court less than 24 hours later to bring Ricardo Jr. We arrived at court on June 19th, 2014. Ricardo was taken to the children's room to be interviewed using forensic techniques by Ms. Elizabeth Leanne Chansey, the court-appointed guardian ad litem in juvenile court. Before ever reaching the courtroom, Elizabeth Leanne Chansey had already begun her plan of criminal prosecution of the parents, even the defendants in this case. Then all 10 of those happy and healthy children were taken into DFCS custody and placed into foster care at Ms. Chansey's request, and she obtained those juicy transcripts she promised in the email that she sent to her former employer, the Gwinnett County District Attorney's Office, where she also asserted that none of our biological children had ever had any education because they were homeschooled. Ultimately, all 10 children were placed in public school at grade level and are performing, as you heard, very well, all A's and B's, and oh yes, 1 C, yet had no prior education. I have to point out that Ms. Boone admitted that she had given prior testimony under oath at 2 prior proceedings in this criminal case. That was not true. Ms. Boone alleged that just one day after these children were taken into custody, Isaiah's bump on his belly, can I grab?
Yes.
Ms. Boone alleged that just one day after these children were taken into DFCS custody, Isaiah's bump on his belly was the size depicted in this picture. And were asked if this is what, no, I'm sorry. However, when each of his siblings saw the picture and were asked if this is what Isaiah's bump looked like when he was at home, you not only heard their words, you saw their startled expressions and heard their assertive no's and heard and saw their physical depictions of the small size of his bump when he was at home, and that it was, and they asserted that it was only on his left side, not all the way across his body. You noted that they were shocked at what happened to their younger brother Isaiah since entering foster care, who apparently they had not seen too much since entering into foster care. I almost forgot. Isaiah also alleged that it was yay big and that it was all the way across his belly on both sides. I can tell you this about Isaiah. He's not a child that lies. And I won't say that he was influenced. Instead, I'll just say, maybe he doesn't remember. It has been a long time. So now let's look to Dr. Rafkin's explanation. That a bump this size on a child's abdomen should not have gone unchecked. And I agree. Well, as his siblings, who spent every day with Isaiah, literally since his birth, as they were there, until their removal by DFCS, showed and told you Isaiah's bump was not anywhere near this big. In fact, his older sister was able to confirm Isaiah's visit to the hospital, where a doctor said that the bump was just soft tissue. It's amazing what children remember, even given the amount of time. So for Isaiah, I'll call it reasonable doubt as to counts 6 and 7 of the indictment, that between the dates of January 1st, 2013, and in the indictment it says July 15th of 2014, Isaiah's parents had caused him no physical pain. And I leave with you the question of what happened to Isaiah since he left his home that caused this little bump of soft tissue to grow, and aggressively so, over the last 2.5 years, or what caused the genetic mutation. And the most recent picture of Isaiah's belly looks like this. If you are familiar with the prophet Isaiah, he suffered much as well and maintained great spirits. Well, meet the modern day Isaiah, for whom his parents did not cause him any physical or mental pain, and in fact had sought medical care when needed. Dr. Saima Hussein, who was on the witness stand and sworn before we knew her name, confirmed that her exam of Ricardo, after being placed in foster care, like Ms. Boone's, showed that Ricardo was well developed, well nourished. Please allow me to say that again. Her report stated that he was well nourished and that everything looked great, but later found that his vitamin D was low. Dr. Hussein confirmed that those people with darker pigmentation typically have a low vitamin D. She also stated that she was told that Ricardo limps occasionally, but had never personally seen him limp at all. She spoke briefly, not as an expert, nor as an orthopedic doctor, about growth crease lines and osteopenia, but never mentioned referring Ricardo to an orthopedic doctor for further investigation. She also stated she followed up on the level of vitamin D, but could not really determine the date nor the new level, though she had reviewed her notes the night before. And I have to add, if there was a grave vitamin D deficiency, certainly we would have seen rickets. The state attempted to show that Ricardo's diet was deficient in vitamin D by saying that Ricardo never drank milk. But to his dismay, he didn't know that when we make oatmeal, we use milk and not water to enhance the body's ability to absorb the vitamins and minerals. Ricardo also confirmed that he ate oatmeal, peanut butter and jelly, rice, tuna, pasta, among other things. Well, the doctor's notes and her testimony confirmed that Ricardo presented well-nourished and well-developed. Ricardo Jr. confirmed he had food and water daily, and moreover, countered the argument that he didn't drink milk. So for Ricardo, I'll call that reasonable doubt for counts 2, 4, and 5 of the indictment. Dr. Ash, the expert in this case, stated that he could not identify any diagnosis in terms of normal or typical mental health diagnoses, but he stated that he had concerns about Ricardo Jr.'s personality. Then Dr. Ash further stated that it would be inappropriate to judge or assess a child or an adolescent by their personality. Yet, Dr. Ash stated that because all Ricardo could think about was being with his siblings while separated from them in his own home and of his own choosing, that Ricardo Jr. must have suffered. Dr. Ash also acknowledged that Ricardo had not seen his parents because of their incarceration due to alleged child abuse, and had rarely seen his siblings since being taken into foster care as of his July 5th, 2016 evaluation. Yet, he wasn't able to consider any suffering that this total separation in different places with little or no contact with those same loved ones he longed to be with could have caused. Dr. Ash also indicated that Ricardo Jr. was not assertive and was at risk of exploitation. But Ricardo's oldest sister, well, his next oldest sibling, his oldest sister, Joy, countered this while discussing Ricardo Jr., his calf muscles, and basketball. Yes, the two of them have always been very close. It's not necessarily my intent to negate an expert's opinion, but I think Dr. Ash negated it early on by stating that without knowing Ricardo before his room was in the basement, Dr. Ash couldn't give a completely accurate evaluation, yet he still did, and insisted on his opinion in spite of possible changes to the conditions. Hence, Dr. Ash could not identify a diagnosis with any medical certainty that Ricardo Jr. had suffered mental pain due to an alleged lack of mental stimulation and social interaction, as in fact he received both daily from his parents. I'll call this reasonable doubt for counts 1 and 3. I hope I haven't put you to sleep, because now I'd like to ask you not only for a verdict of, let me get it right this time, not guilty, but that you let Yah's people go so that they serve him. I assert that we are not guilty of all 7 counts of this indictment. So please, I request of you that you let Yah's people go. Thank you.
All right, thank you, Ms. Wimbush. If I could get the bailiffs to maybe remove the whiteboard into the hallway, that'll probably be the easiest. They don't have to be in a certain order, that's fine. Thank you. Let me let the bailiffs come back and get situated before you begin, Mr. Mayfield. All right, Mr. Mayfield.
You have to wait the TV for me, please. Thank you. Morning, ladies and gentlemen. I know that you have been read the indictment multiple times and been exposed to what the elements of the offenses are, but it's always so wordy. You know, I thought I might just try to condense it for you a bit and explain something about the 7 charges in the indictment. I know this is a little bit small, but counts 1 and 2 are in red. And it reads, the top line reads, count 1, cruelty in the first degree. And the state must prove malice for that, so that's what we call the mental state. Malice. The victim's name is Ricardo, and the harm is mental pain by confining the victim without sufficient mental stimulation or interaction. Count 2 is also cruelty in the first, because it requires malice. The victim is Ricardo. It's physical pain by failing to provide exercise. Now, count 3 is exactly like count 1, except it's in blue because it's cruelty in the second degree. So actually, because negligence is a lower criminal state of mind than negligence is, count 3 is included inside count 1. Okay? So, if there is a guilty verdict on all counts, then count 3, 4, and 7, the lower offenses, just fade into the other offenses. It's not additional conviction. It's with, so if a guilty verdict on count 3 falls within a guilty verdict on count 1. The only time that makes a difference is should you, the jury, make a decision that the state didn't prove malice, that we only proved negligence. In that case, you should return a verdict of not guilty of count 1, not guilty on count 2 malice, but guilty on count 3 and count 4. You have that option. Those are legal options for you. There is no cruelty second for count number 5, so it's not malice either. And we'll learn in a few minutes the difference between malice and willfully versus negligent. So just wanted to explain to you counts 6 and 7 apply to Isaiah for cruelty in the first, for count 6, and cruelty in the second, for count 7. So you understand that it's impossible to return a not guilty verdict on count 7 and a guilty verdict on count 6. It's impossible because it's a lesser offense. Okay? So a guilty verdict on all counts means that guilty of 4 charges. You have options. The state's position is that the only appropriate verdict will be a plea of a finding of guilty on all charges. And I'll explain to you why that is the state's position. The state must prove the guilt of the defendant beyond a reasonable doubt. What does that mean? It's not beyond all doubt. This is not the state must prove to a 100% mathematical certainty. That is never the state's burden, ever. Because if it was, no one would ever be convicted of fraud. I know sometimes on TV it looks like we can prove cases to a 100% mathematical certainty. Makes for really good TV. Has nothing to do with reality. So the standard of proof is not that we prove it beyond all doubt, but to a doubt based upon common sense and reason. So your job is it reasonable to believe that the defendants did the acts and the victims suffered the consequences? If your common sense and reason leads you to that conclusion, then your oath will require you to return a guilty verdict. And also, of course, the defendant's acted with malice. Okay. Lastly, we're going to talk about whether or not the defendant's actions were justified. But we'll get there. There's 7 charges in the indictment. There's some very interesting things that are not in the indictment. There is nothing about charging DFCS with doing anything wrong. If DFCS ever did anything wrong, guess what? There's a courtroom for that. There's a jury for that. That's a separate issue. This issue consists of solely the charges in this bill of indictment that you will have at with you. So don't concern yourself with anything about family and children's services. Don't concern with yourself anything about the defendant seeing the children, because it doesn't contribute to your decision as to whether or not the defendant's committed the crime. Right? Because everything that's alleged here happened before that happened. And so it can't influence anything about the indictment. Whether or not anybody's in jail has nothing to do with whether or not they're guilty. Is it a factor? Maybe if somebody's in jail, they're less guilty. If they're out of jail, they're more guilty? No, it's irrelevant. How many times did you hear me say, it's not relevant? That's because I know, and you know, that the trial is about these charges. It's not about these issues that Isaiah didn't get sick at home. Has nothing to do with it. Has nothing to do with what happened in juvenile court. Has nothing to do with funding the Wimbush houses. Has nothing to do, believe it or not, when you think about it. That the children love mom and dad, and mom and dad love the children. Sometimes love has nothing to do with it. People that love each other hurt each other and kill each other. And if the person that you were to kill, that you happen to love, does that make you not guilty of the crime? So their relationship doesn't matter as to whether or not they committed the crime. It's a side issue presented by the defense. You know, it's not like it's a balancing test. You know, how much good did they do versus how much bad did they do? Guy walks into a McDonald's. He wants to rob it. He has a gun. He kills somebody. Is it a defense to say, I didn't kill the other 6 employees, and I took the money that I stole and I gave it to charity, so I'm not guilty. I'm a good person. You should balance out the good things I did versus the bad things I did. No. No. You're responsible for the evil crimes that you commit, regardless of whether or not you love your victims. So, none of those things are relevant. If you are in the jury room and you are talking about any of these things, what are you not talking about? The charges in this indictment. Focus on what your job is. Juvenile court people had a job. They didn't try to do your job. You shouldn't try to decide what other irrelevant issues, how they should or should not be decided. Focus on the issue in this case. Nothing else is relevant. Now, what has the state proven? And I'm not going to go through all the pieces of evidence, but when I mention what the state has proven, you'll remember what that evidence was. The state has proven beyond a reasonable doubt that the defendants are the parents of Ricardo and Isaiah. That Ricardo, we're talking about Ricardo now, he lived in inhumane conditions in a small room, isolated room, locked in that room. That's proven beyond a reasonable doubt. Even the defense admits that. He suffered physical pain from low vitamin D levels, both types. He suffered muscle atrophy that caused him pain. He suffered bone disease. He suffered a fungus growing on his skin because he did not shower or bathe for months and was never even given clean clothes. He suffered mental pain, and that's proven beyond a reasonable doubt. Sadness, loneliness, extreme boredom is painful. In the future, he will suffer mental pain because of what these defendants did. He will struggle with relationships. He will have to work on his personality because of what the defendants did. He will struggle more than that. What's going to happen, do you think? He gets into an elevator by himself with the walls of colored blue and the bushes. Proven facts. We're going to talk about Isaiah. What do we know? The defendants are his parents. They're responsible for his care. We know that he has been growing a visible skin cancer for years that has slowly spread. It started small, and it got bigger, and it got bigger, and it got bigger, and it got giant, and it got out of control. We know it looked like this right after taken into de facto custody. How do we know that? We know that that picture was taken right after he was removed from the home. And when Isaiah saw that picture, what did he say? Yeah. Yep. Who knows better what Isaiah's belly looked like? Isaiah or his siblings? Why did the siblings not know what Isaiah's belly looked like? Because it was just one of those things in the household that you just accept like it is. Isaiah's got a bump. Everybody knew it. Parents aren't going to do anything about it. Like everything else important, it got ignored. So the other siblings weren't on a day-to-day watch of Isaiah's belly. It had been there for years. That's why they didn't know how big the bump was. Now, proven facts as to Isaiah. The only evidence of medical care for Isaiah, get this, was at some absolutely unknown date. We have no idea. That he went to an emergency room with his parents while they were at a wedding. Does anybody think for a minute that he was taken to the emergency room because of that bump while they're out at a wedding? For whatever reason he was at the doctor, at the emergency room, apparently one of the siblings heard somewhere that the doctor said that it was nothing. Was that sibling in the room with the doctor? Or did that sibling get that information from somebody else? Do we know if that's true? And if it was true, did the doctor see the keloid? There was a keloid there. Is keloid a cause for concern? No. Now, we also know that it's been proven there were no annual checkups. For year after year, as that cancer was growing inside that child, all that child needed was one visit to a pediatrician. And that cancer had a 99.9% chance of getting cured. That never happened. Who's responsible? Isaiah? Physical pain. We know he has suffered surgery. He will be suffering surgery again. We know that every time he faces surgery, that surgical area gets bigger and bigger and bigger. And they will be doing flaps of muscle and skin grafts, and that he will permanently be scarred for the rest of his life. And he may be facing this cancer for a long time to come. And there is even a chance it could kill him. Who is responsible for that? Isaiah? We're going to talk about criminal intent. So first of all, there's criminal negligence. And this just means like, gee, I wasn't paying attention and something bad happened. That's what criminal negligence is like. I should have been paying more attention, I should have been more careful, but I wasn't, something bad happened. Is that what applies in this case? Willfulness. Willfulness is between negligence and malice. It is an act of the will. It's less than actually intending to harm, but it's more than negligence. So it falls in between criminal negligence and malice. Now let's talk about malice. The court was going to tell you this, that the wanton and willful doing of an act with an awareness of a plain and strong likelihood that mental or physical pain will result. So, when the defendants are taking care of their children, did they do so in a way that was a wanton and willful doing of an act with a plain and strong likelihood that mental and physical pain will result? Malice is not ill will or hatred. It's not. A husband and a wife that love each other, that get into an argument, and one kills the other, can still be malice. Has nothing to do with love or hate or ill will. It's doing of an act with an awareness and a strong likelihood. Okay. So after sleeping in this sleep room with all of his siblings for his entire life, after living in a house filled with books and toys and Legos and yarn and games and all sorts of fun stuff, after growing up in that, it looks like this. Look at where he grew up. Animal cages, movies, books, everywhere. What an incredible environment for a kid to grow up in, it would seem on the surface. Plenty to do. And then Ricardo got a new life. So his parents took him from that with very little time span to adjust to a life where all mental stimulation suddenly became negative, where he started to become uneducated, where he went unbathed, where funguses were growing on his skin, where his bones were deteriorating, where he lived in darkness, in boredom, and in loneliness. Worst of all, hopelessness. Hopeless. Tried running away. Last ditch effort. Where did it be? Right back in the basement. There was a lock on the door, but it was on the outside. He was so helpless he couldn't go to the bathroom when he needed to. Who takes a 12-year-old son and puts them in that position without malice? Who changes their life so dramatically in such a short period of time that you don't know it, that you don't know what you're doing, that you don't know the likely outcome of what you're doing to that child? This was his life. That's it. You see his entire life for months on that screen. He had nothing else. Imagine. Negative messages puffed up. Pretentious, presumption, prejudice, ruin, putrid, ridicule, rotten, rebel, ignorance, death, disdain, disrespect, darkness, defiance, evil, egotism, exile, envy. That was his only mental stimulation for months. Can you imagine that not being malicious? When you get the pictures back there, it's going to be more clear than what you see on the screen. Look at that mattress. Look closely. Look at the filth on that mattress. Look beside that mattress and you will see piles of dead hair and dead skin that had collected for months. Look at that picture. What does he have? A cup, a bag with some bread in it, a couple of miscellaneous items. No book, no education, nothing. That was the life. That was the life that his parents gave him. Why is it malice? It's because they not only knew what they were doing to him, it was their intention to do that to him. They intended the emotional and physical pain as punishment. That's what they were after. That's what they got. Pride. Let's talk about pride. Let's talk about the words that she put on his wall. Pretentious? Who's pretentious? There's pretentious. There's, I've got all the answers, and I can do what I want with my children. That's pretentious. Putrid? Putting your child in an environment where fungus grows on its skin is sickening and is putrid. ruin 2 of their children's lives. Ignorance. They want to tell you how smart they are. And they did tell you all about their degrees, and they're ignorant. How are they ignorant? Ricardo was in a swimming pool on the shallow end. And he, like all kids, are growing up. And guess what? He, like the best of us, don't want to spend our lives in the shallow end. We grow in the swimming pool of life when we go to the deep end. That's how we all grow. If we didn't do that, we would all still be 12. But Ricardo made a mistake because she said, "You want me to help you on the deep end?" And he said, "No." And what's the one thing you never do in that house? Tell Mom no. So like every one of us that had to go in the deep end, when we were in a car for the first time and we were scared, but we overcame our fear and we learned to drop out. When we were a little bit older, we had to make our own choices about alcohol, about how fast we were going to drive, about who we were going to have a relationship, and what is the nature of that relationship going to be. And we build on experiences by stepping out and learning. And that's all Ricardo was doing. Except he made a mistake. He told her he didn't need any help. And he tried it on his own, and guess what? Like all of us, sometimes it works for us, and sometimes stepping out doesn't. So yeah, she needed to save him. But she was mad at him and called it prideful that he was trying to develop himself further. And that is such a key story here. The key story is that they are under her thumb, and they can't do anything without her. That's what life in that house was like. Darkness, obviously. Death, let's hope not. Only time will tell. Exile. Who exiles their own child? Only evil does that. Only evil, not Ricardo. Only evil does that. These are her words. But they don't apply to Ricardo, they apply to her. So the state's case. We've proven and we've talked about what the defendants did. We've proven and we've talked about malice. Are you done? Maybe not. Maybe there's a defense that applies. So there's a defense called the justification defense. It's pretty common. Self-defense is justification. Shooting somebody is normally a crime, but if they're trying to kill you, guess what? You're justified in the shooting and it's no longer a crime. Okay? There are several types of justification in the law, but there's one that's important here. You're justified in spanking your child, which is a crime of battery. One person strikes another, we call that battery. But it's justified, and it's not a crime if you do it as reasonable discipline of a minor by his parent. There's only one key to this defense. If it's not reasonable, it's not a defense. So what we need to do is look at what Ricardo's conduct was to see if the punishment fit the crime. He stole a book that was in his house amongst hundreds of other books. But when Ricardo gets it, it's stealing. Punishment does not fit the crime, and the punishment is not age appropriate, and under no circumstances could it ever be reasonable. So what was his behavior? He might have played doctor when he was a young kid. Hope says that he violated his siblings' privacy. Wow, where'd you come up with that term? Now notice she didn't say her privacy, and notice that none of the children ever testified that it happened. And remember that investigator Boone said that Ricardo had no memory of it, and that the doctor said there is absolutely no evidence of sexual intent or deviation, that he was tested for that and it came back normal. So where do you think that idea came from? as justification. Ricardo lied a lot. Okay? I did too. He read a book, a DVD player. And why is it stealing? Because he was too afraid to ask permission. He was living under that iron fist to such a degree he couldn't ask for permission to read a book. He thought he might get punished. So he took it out of boredom and he stuck it in that little blue room between the mattress and the wall. Because at that time, the lock wasn't on the door. We had almost no contact with the ceiling. Sometimes it would let him up. Remember, this went in stages. He was down in the basement for a while, and he said when he was living in the basement, even in the gym, he said he would watch his siblings go out in the yard and play, and sometimes he got to do that. But in a very short period of time, they pulled all the junk out of the storage room, threw his mat in there, made that his bed. So he was bored, and he wanted to read a book like he was accustomed to doing. But yet, it's stealing when Ricardo does it. His really bad behavior was when he came upstairs without permission. This was before the lock was applied, obviously. So he came upstairs, got caught, got beaten, got sent right back down to the basement. And then he ran away. Why? Because he didn't want to face the consequences. He would, at 12 years old, he would rather run away from home than face the consequences of being in trouble with mom and dad. The defense. The defense is, Ricardo wanted to be in the basement. Well, let's look at that. Ricardo never asked to be locked up. Is it possible or probable or truthful that he may have asked to be sent to his room instead of spankings? I've done that. That's a far cry from wanting to be locked up. Ricardo didn't think he was ready to come up. Ricardo told mom whatever she wanted to hear, period. Ricardo believed he deserved it. He was 12. Those are his parents. Who convinced him that he deserved to rot in a blue small prison cell for months? Who convinced him that that was right? The only people that ever communicated with him convinced him that that's the right thing to do to a 12-year-old, and they're blaming it on him. Sibling said, Ricardo lied on me. Ricardo was a sibling. What do siblings do? Are siblings perfect? Ricardo, remember, was the eldest. And so, as the eldest, he is now starting to step out and try to swim in the deep end. But everybody he knows is younger than him in this room, other than his parents. So, he's the eldest, and what's he going to try to do when you're 12? You're going to try to stretch the limits of your authority, aren't you? Do you find that to be true in life? He was the eldest, and so he was trying to get his way, and it wasn't working for him. This was, as I told you, a sad home. This home was full of mental pain. This home was full of physical pain. Defendants want to try to convince you that this was a happy home. As long as, and it was. It was a happy home. There's a lot to do there, and they had lots of fun together. And it's a happy home if you ignore somebody dying of cancer. And it's a happy home as long as you don't talk about the pink elephant in the room. And nobody talked about the pink elephant in the room. Only it wasn't a pink elephant. It was a 12-year-old stuck in a blue room. So as long as everybody ignored that, it was a happy home. And that's what they taught their children to live home life like. So we have 2 children in that home, their lives forever altered. We have 8 children that were taught it was right to do that, that we're taught it's never right to question your parents. What had happened if Ricardo was really bad? What if he'd really done something wrong? Where would we be? What was in store for the next child that gets 12, 13, 14 years old and starts looking for their way? What was going to happen to the next one? Ricardo and Isaiah will pay the price for the rest of their lives in one form or another. Their childhood was stolen. So they're paying the price. Do they get off scot-free? Or do they pay the price? Do the defendants share part of the burden? And that sharing of the burden would be a guilty burden. The children shouldn't be the only ones that pay. The defense is that Ricardo chose. His choice was to choose a room over spanking. There was never a conversation. He said that he was alone in his room, and then, without notice, without a conversation, he heard the drill and the lock was on his door. Where was the consent for that? That is the only evidence there is about that lock going on the door. When Ricardo said, I was in my room and they put the lock on my door. No conversation, no talking about it, nothing. There he was. He told Mom what he wanted to hear. If he was free to come up, if it was truly Ricardo's choice, before the lock was applied, if it was Ricardo's choice to come upstairs, then why, when he was upstairs, did his dad beat him and send him back downstairs? Does that show us that it was Ricardo's choice to be in the basement? No. They want you to believe that it was his choice. But when he came upstairs, he was beaten and sent back down. He never had a choice in this matter. Who would choose that? Who makes the choice? The 12-year-old or the parent? The defendants are free to choose their religion. It has nothing to do with that. They can choose as they believe. They can start out Christians as they choose. And if they decide there's no more forgiveness for Ricardo, they can choose to change that religion. There is nothing wrong with that. The law says you can spank your children. The law says you can force your children to have permission before they can read a book. That's within the law. You can rule a household with an iron fist if that's your choice. It's not against the law. Thank goodness none of those things were against the law. But you're not free, ladies and gentlemen, to commit cruelty to children and use that as an excuse. You're not free to deny your child with a growth on his belly that is expanding ever larger and becoming more tender to where he bumps into things that hurts. You are not free under the law to ignore that and to refuse medical care. This is not Ricardo's fault that the defendants were arrested. It is not Ricardo's fault that they don't live together in that house anymore. It's not Ricardo's fault that they went to juvenile court. Yet these defendants want to blame their 12-year-old. And they asked you for a not guilty verdict because it was Ricardo's fault. I submit to you, there's only one verdict that will speak the truth. Guilty on all charges.
Thank you, Mr. Mayfield. All right, ladies and gentlemen, my instruction or charge to the court will take between 15 and 20 minutes. Does anyone need a rest break before I do that? Show by hands, otherwise I will proceed. All right, not seeing any hands. Let me let the courtroom clear out.